as a sub, file item number 1, SB 816, Senator Hill, regarding the State Board of Equalization members' contributions to public policy. Sir.
Good morning, Mr. Chair and member.
And member.
816 ensures that all contribution amounts to Board of Equalization members are subject to the Board of Equalization's existing disclosure and recusal rules. The bill would prohibit board members from participating in adjudicatory proceedings when they have accepted any contribution from the taxpayer or any other person related to the case within the prior 12 months. Everyone would still be allowed to contribute any amount they wanted to Board of Equalization members within legal limits. This bill just requires that all donation amounts trigger disclosure and recusal if it's done 12 months prior to the proceeding. Former Senator Quentin Kopp authored the original conflict of interest legislation in 1991, but limited the disclosure and recusal rules to contributions of $250 or more. The former senator and I agreed that the $250 threshold should be removed and that all contributions should be subject to the disclosure and recusal requirements, since the Board of Equalization is the only elected tax commission in the nation. The bill is supported by California Common Cause, California Public Interest Research Group, and Board of Equalization member George Runner. I have some witnesses in support, Mr. Chair. Thank you.
Okay, let's hear from them. Thank you, sir.
Thank you.
Hi, I'm Emily Resch, the Executive Director of the California Public Interest Research Group. We're here in support of the bill. We think it will improve public trust in the Board of Equalization.
Nicholas Heidorn with California Common Cause, also in support of the bill. This is the only elected tax board in the nation, but also performs an adjudicatory function. So ensuring that board members are impartial and that there's a perception of impartiality is important. We think recent articles showing how people have gotten around the recusal limits by having multiple donations just under the limit coming from a single firm illustrates the importance of this legislation. Thank you.
Thank you so much. Any further in support? Opposition? Please.
Good morning, Mr. Chair, members. My name is Josh Tillard Gates, and I'm here on behalf of Jerome Horton, member of the Board of Equalization, to express our opposition to Senate Bill 816. It is our belief that restricting even small contributions of $1 to board members, although seemingly innocuous, is unnecessary and, more notably, is a violation of the First Amendment right of freedom of expression without a legitimate public interest. The U.S. Supreme Court in McCutcheon v. Supreme Court in 2014 recently threw out the contribution limits on what an individual can give to candidates and political committees. Chief Roberts said those caps infringe on First Amendment free speech rights and aren't justified by the public interest in fighting political corruption. In McCutcheon, the court has also identified the one legitimate government interest for restricting campaign finances, which is preventing corruption or the appearance of corruption. Expanding on this issue, the court stated that while preventing corruption or its appearance is a legitimate objective, Congress may target only a specific type of corruption, which is quid pro quo corruption, the exchange of favors for money. The author of Senate Bill 816 submits that there is no legal, factual, or evidence of political corruption that demonstrates the need for this measure, thus raising the issue of constitutionality under McCutcheon. In an earlier case in 2006, Randall v. Sorrell, the Supreme Court found that Vermont's limits on contributions to be so restrictive as to violate the First Amendment. The court noted that the contribution limits in the Vermont law were the lowest in the country and that they were not indexed to keep pace with inflation. Similarly, the current COP Act limits on contributions to board members are already the lowest in the nation and are not indexed to keep up with inflation, as the legislature has not raised them since its enactment in 1990. Based on Member Horton's conversation with the author has also acknowledged that there's no evidence of a public outcry for help. However, it has been presumed that because the Board of Equalization is an elected adjudicatory body, its decisions on taxpayer matters carry the weight of finality like a court of law. This is a misunderstanding because the board is an administrative body where taxpayers exercise their right to administrative due process only. The board's decisions do not carry the finality of a court, and if a taxpayer files a case in court that was decided by the board, the court considers it as a trial de novo, a brand new matter of law and facts. The current contribution limits of $249 to members of the board are the most restrictive in the nation, and current law requires the aggregation of all the contributions from a party, participant, or any of their agents who appear before the board. Further, because this measure treats citizens who contribute $249 to members of the board differently than those who contribute $1,500 to judges or perhaps even more to legislators, both having far more influence over taxation in California, this measure also violates the intent of the Equal Protection Clause. If passed, this measure, based in the history of like legislation, will become a stepping stone for future legislation based on similar presumptions that somehow a contribution of $249 or more influences the votes of elected officials. If the assumption of Senate Bill 816 is correct, that there is a perception problem, then it should apply to legislators the same as it would apply to board members. Only then would the perception issue of contributions influencing votes would be universally addressed. In closing, Mr. Chair, members, Board Member Horton believes that this measure creates a new standard, do as I say, not as I do, that is not fair, on balance, or protective of the rights of California citizens. We oppose Senate Bill 816 unless it is amended to apply the same rules equally to judges, legislators, the governor, and all other elected constitutional officers. Thank you.
Any other further opposition? Any questions from the members? Senator Morlock.
Thank you, Mr. Chair. I think this is a pure bill. It all makes sense. I'm trying to figure out how it works in the real world. So I'm concerned, Senator Hill, about the reverberations. Could you comment on the argument that it might affect other offices downstream?
Which other offices? The other offices
Judges,
well,
senators?
this bill does not apply to other offices. It applies to Board of Equalization members.
But I'm asking, what would be the reverberations? Would there be any? Is that argument a good argument?
Well, no, I don't believe it is a good argument because we're dealing with tax policy here. We're talking about tax decisions that are made. We're talking about the contributions that are made within a 12-month period of that member. We're not limiting any contribution only for those of cases that are coming directly before the body. There's no limitation. This applies to no restriction on any contribution other than if it's a decision that comes before that body in a direct tax case. And the issue of having this bill apply, the argument that was made that is, there's a constitutional question, that there are court cases in the past that have allowed for and found that these types of restrictions do not apply. If that's the case, then if we were to apply it to everyone, then you can't have the same argument. Then it would be unconstitutional or illegal, or it would not meet that test if it were applied to others. So we look at this as just applying to the Board of Equalization. We've not seen issues of where we've noticed the aggregation and the bundling of checks for sitting members or sitting judges that we've seen here. So the problem seems to be applied only to the Board of Equalization.
The State Board of Equalization is 1/4 of the state when you're running, so it's a big fundraising challenge, and we both know how difficult it is to raise money, and SBOE doesn't sound like a sexy seat to me, so it must be even more challenging to raise money. So I'm wondering, isn't the media or opposition research an effective tool? So if someone took a contribution and voted in favor of the donor, wouldn't that be incredible headline material that would be like a good...
I don't want to have to depend on the media to have full disclosure and truth and ethics in government. I want to rely on good legislation that can put those restrictions. The fact that they have a $250 limitation today. And again, this only applies to those cases. They're fundraising of the millions of individuals who are within their district. This will only apply to those handful that probably have cases that will come before that body in that previous year. So it's a very limited number of people, but what this will prohibit and prevent is the bundling of contributions, which seems to have gone on to some extent in the past, and we don't know where that can apply or where that can come from. This will put a stop to that.
Just take one moment before you, have another question.
Yeah, one last question.
Establish, no, go, please, question, let's just ask the question, just like to establish quorum quickly.
Okay.
Secretary of the roll.
I just want to know,
Oh, just one question. Yeah, thank you. Here,
Hertzberg.
Present.
Hertzberg present. Nguyen. Nguyen present. Bell. Bell present. Hernandez. Laura. Morlock.
President,
Morlock present. Pavlik.
Thank you, we have a quorum. Please proceed.
I'm just curious, Senator, how does Quentin Kopp's bill or act differ from the Levine Act, which Senator Nguyen and I were subject to when we were on the Orange County Transportation Authority? I found it an interesting bill that if someone gave enough of us 250 or more, we couldn't vote on the matter. And I thought, boy, if someone could play it right, they could prevent a loss of a contract by just contributing to us. But I'm just,
I don't know how that, the Levine bill.
Wasn't that the Hayden Act? That was it?
it was a Levine Act.
Assembly member.
Why do all of these tax acts have people's names attached to them? These contribution limits.
Thank you, Senator.
Thank you, Senator Morlock.
Any further questions among the members? Just one of the thoughts that I have, certainly I think that, you know, that crossed my mind about this. I know you reached out to me. I apologize to get back to you, Senator, but just as a thought is this $250 contribution, you know, Senator Kopp put together with respect to this matter kind of is a threshold in some other areas of the law, certainly in transportation policy. I don't know if it was Senator Levine. I know Tom Hayden did a similar thing with respect to the Metropolitan Transportation Authority in Los Angeles. And I don't think it's a real practical matter. I just think for purpose of the record, it's important to raise it in a hearing like this is, what if someone made a $25 contribution or a $10 contribution is an effort to disqualify folks, or the case may be? You know, what does that look like in terms of the size? I mean, clearly, in our analysis, it shows that there was an instance where 49 contributions totaling $11,000 at $249 from a similarly associated organization creates the kind of impression I think that you're trying to deal with here in why you brought this, you introduced this legislation. But what if it was small contributions, and what's the administrative cost of dealing with that? Because what will happen, I would suspect, that if you're a member of the Board of Equalization with the kinds of constraints that Senator Morlock talked about, and somebody gives you these small contributions, you're going to spend more money in accounting fees, no knock on accountants, than you are to administer these kinds of fees for these small contributions.
If I could respond.
Of course.
The issue, the recusal requirement only applies if you've accepted the contribution and you did not return the contribution within that period. You can return the contribution and not have to recuse yourself if $25. I mean, I know in the bookkeeping and the treasurer for my account easily can type in the name of an individual and find out what contributions they have, and the treasurer mails a check back if that were necessary. So it doesn't prohibit or require the recusal. It just allows you that opportunity.
Senator Nguyen.
Mr. Chairman, just to add to what you said and what Senator Morlock, when we were restricted at, for our special districts as county supervisors, one of the challenging thing was we would be at the Orange County Sanitation District, and we would have a list of 2,000 contracts that we're renewing for the district. And my staff would literally have to go through 2,000 of those just to make sure that I somehow, and 99.9% of them we don't get contributions from, but we would have to go through, you know, 200, 100, 1,000, or whatever it is on these small districts, just to make sure we didn't, you know, miss anybody, or because of the Levine Act. And would that affect the BOE by imposing this? I just don't want it to be a burden of, it almost became like a full-time job for one of my staff, just to, because we sat on at minimum 10, 15 boards all across the county, and every week, every other day, we had a board meeting, and one staff literally just goes through the entire list just to try to match it. I mean, it doesn't go through your treasurer, because your treasurer, you're right, you can just call your treasurer, hey, can you just return this check? But going through these donor lists and the contribution, I mean, and the contractors, it's horrendous. And I don't know what the BOE's schedule and how they vote on these things and how many are at a time. You know, so I just want to bring that up.
Yeah, and I think it's a valid point, but I think the difference is, as someone who was a county supervisor and a city council member, the contracts were unlimited. When you look at the number and the volume of contracts that you would approve on a consent calendar. And if you had to do that, that would be extreme. In this particular case, my understanding is, and the way this applies, is only for those cases that are coming directly before the board, and those would be the ones that would be considered. And I don't believe that rises to that same level of volume.
Any other questions? Senator Pavley, anything? Okay. Just before you close, Mike, I want to, I'm concerned some of the points that President Horton raised on this stuff. I don't think the constitutional arguments directly, because I do think there's a distinction. I think you draw that in the bill, and you've made it in your comments here about the adjudicatory nature of this proceeding. But I do think there's some sensitivities where you have judicial proceedings where if a judge runs for office and accepts a bunch of checks from lawyers and then runs and then has a case before them, or you think about somebody running for office probably takes a lot of checks if they represent this big 25% of the state, and they probably have to disqualify themselves for the first year in office, I would suspect, because they didn't know that anything was going to happen. It's for a year. I do think there might be some equal protection issues, and all I would ask you, I certainly want to support this measure today, Senator, but I would spend a little time with Chairman Horton to examine the equal protection argument. I think it might bear a little bit of attention. I haven't drilled into it enough, but
We'll do that.
I'd like to do a little homework on that, okay? Thank you, sir. Do you have a motion? Do you want to close, sir?
No, I just respectfully ask for an aye vote, Member.
Thank you. Any motion?
And thanks for the conversation.
A bill moved by Senator Pavley. Secretary, call the roll. Oh, do the motion. It's the motion to, that's right, it's due pass to elections. Thank you. Okay?
Hertzberg,
Aye.
Hertzberg, aye. Wynn,
Aye.
Wynn, aye. Bell, Bell, aye. Hernandez, Laura, Morlock, Pavley, Pavley, aye.
4 votes. We'll hold that for the members who still want to add on. Okay?
Thank you very much.
Don't you have one other measure, sir?
I do, SB 996.
Sorry, it's file item number 996.
Thank you very much, yes. SB 996 will aid, and you saw this bill earlier this year, SB 996 will aid nonprofits and religious organizations that provide affordable housing by increasing their property tax exemption from $20,000 annually to $100,000 annually. 4 out of the 5 least affordable rental markets nationwide are in California. 4 out of 5. Nonprofits that do not receive any tax subsidies or grants from the state and that provide affordable housing to low-income families have a cap placed on the amount of property tax that may be exempted annually. There are only 76 different properties in California owned by 26 nonprofits that are currently being reported to the Board of Equalization by the county assessors that are subject to this cap. Only 8 of these are close to or over the cap. The 3 charities in my district are the only ones in the entire state currently over the cap. So I ask for your aye vote on this, members. You heard this earlier, and it was held in appropriations, but the chair said that to bring it back, this is more of a process question than a policy one.
Witnesses in favor? Bill's been moved. Witnesses in favor?
Greg DeGere with the Arc and United Cerebral Palsy California Collaboration, a coalition of people with intellectual and developmental disabilities and their families, friends, and service providers. Adults with developmental disabilities in California overwhelmingly live with poverty-level incomes. And as you can imagine, with housing prices being what they are in California, it is a huge, huge problem for them. This is a step in the right direction, and we support the bill.
Good morning. Steve Cruz on behalf of the San Mateo County Board of Supervisors. Like other parts of the state, the Bay Area in particular, San Mateo County is suffering from a severe housing affordability crisis, so we really appreciate Senator Hill's effort to provide some measure of relief to those organizations that provide affordable housing and other critical services for not just low-income families, but working-class families in San Mateo County.
Very good. Thank you, sir. Any others in support? Any opposition?
Mr. Chair and members, Greg Cook representing the California Assessors Association. We're not in opposition to the bill at this time. We have had numerous conversations with Senator Hill and his staff regarding implementation concerns. We have been given assurances that those concerns are being heard and will be addressed, and we look forward to continuing to work with the author as the bill goes forward. Thank you.
Any further questions from members? I think, bill has been moved by Senator Bell as due pass to appropriations. Would you like to close?
No, I'd just be happy to respond to the assessors, and there are three issues that they raised. One is they'd like to change the $100,000 property tax elimination part to $10 million, which would equate to the same amount of dollars in value. It's easier for them to look at value and assess value rather than dollars, because each county would be different. We're happy to do that. The other issue was that they'd like to have some proof, the assessors, of the nature of the charities and the amount that they're maintaining these properties as affordable, and some proof of that on a regular basis. We're happy to do that. The last one, though, is to eliminate the retroactivity. This bill does have retroactivity. The only county that retroactivity would apply to is San Mateo County, and the county, as you heard, is in support of this bill, so we'd rather leave that in the bill, but otherwise we will be able to work with the assessors to solve their concerns. Thank you. Appreciate your aye vote. Thank you.
Thank you, sir. Okay, this is due pass to appropriations. Secretary, call the roll.
Hertzberg.
Aye.
Hertzberg, aye. Wynn.
Aye.
Wynn, aye. Bell. Bell, aye. Hernandez. Lara. Morlock. Morlock, aye. Pavley. Pavley, aye. 5-0.
5-0. We'll hold that for the members that are still.
Thank you very much, Mr.
Thank you
Chair.
so much, Senator. Appreciate it very much. Okay, thank you. Senator Roth, file item number 2, SB 817. You are one tenacious person. I'd hire you as my senator. A few times. We're going to get this done somehow, whatever it takes. Please, file item number 2, SB 817, Senator Roth.
Thank you, Mr. Chair. I'm back in front of you with my annual crusade to fix the problem for California's 4 newest cities. I know you know this. Prior to 1935, our cities were funded in part through a personal property tax on vehicles at various local rates. In 1935, it was standardized throughout the state by the use of a vehicle license fee. The VLF provided a significant portion of local government funding from 1935 to 2004. Beginning in 2004, property tax essentially replaced the VLF as the source of funding for existing cities. But in the law at the time, there was no state funding assistance for any unincorporated areas that wished to form new cities in this state. That changed in 2006 with a bill by then Assemblyman Laird, when new cities were once again funded through the vehicle license fee. Cities in existence prior to 2006 continued to receive funding support through the property tax. So, with the law in place at the time, since 2006, there have been 4 new cities incorporated in this state, all of them in Riverside County: Jurupa Valley, Eastvale, Menifee, and Wildomar. And as some of you know who were here at the time, in 2011, as part of the implementation of AB 109 and public safety realignment, the VLF funding support for the 4 post-2006 cities was abruptly and inadvertently terminated. I view it as a drafting error, frankly. This inadvertent action left these 4 new cities scrambling to find enough money to continue to operate and fund essential public safety and other services. So, bottom line, this bill corrects that situation for those 4 new cities by providing property tax to them, just as every other pre-2006 city currently receives. So from my perspective, it's simply an equity issue. And I would respectfully ask for an aye vote.
Thank you, Senator. Witnesses in support?
Mr. Chair, members of the committee, Anthony Gonsalves. I represent the cities of Eastvale, Jurupa Valley, and Wildomar, the newly incorporated cities. And I want to thank the author for his perseverance on this issue. It kind of reminds me of a picture behind the Speaker Moretti's desk. It was a picture of a tortoise. It only makes progress when it sticks its neck out. And Senator Roth has been sticking his neck out and being the champion for this, and we appreciate it, and we appreciate your support for the bill. Thank you.
Thanks, sir.
Mr. Chairman and members, Dan Carrick on behalf of the League of California Cities. Also appreciate the senator's efforts in this on this issue. These 4 cities, they played by the rules that the legislature established along the lines of the Laird bill. The League actually helped draft the Laird bill. Cities shared a portion of their VLF to try to help the new incorporated cities. All that was swept in about 6 hours with the passage of SB 89 without any public process. Those cities deserve to be, an adjustment needs to be made for those communities to help them be able to move forward. So we appreciate the bill and urge your support.
Thank you so much. Others in support?
Good morning, Mr. Chair and members. Dorothy Holzem with the California State Association of Counties, pleased to be in support.
Thank you.
Mr. Chair and members, Jelena Voris here on behalf of the urban counties of California, also in support.
Matthew Seiberling on behalf of the Riverside Sheriff's Association, also in support.
Thank you.
Andrew Langley on behalf of the Riverside County Board of Supervisors, in support.
Thank you.
Jonathan Feldman with the California Police Chiefs Association, in support.
Thank you. Any opposition? Questions from the members? Bill's been moved by Senator Pavley, questioned by Senator Morlock.
More of a comment, Mr. Chair.
Certainly.
Senate Bill 89 was a contemptible bill. It harmed these 4 cities, but it also harmed the county of Orange to a rather significant amount of dollars, more than $50 million a year, that Senator Wynn and I had to play a lot of fun times in closed session dealing with the state of California. I'm sorry the bill doesn't include Orange County, but I have endorsed and supported Senator Roth's efforts as a supervisor for every bill, and I am happy to support him once again.
Perfect. Any opposition? Would you like to close, Senator?
Respectfully ask for an aye vote, and thank you for your time.
A bill has been moved by Senator Pavley. Do pass to appropriations. Secretary, call the roll, please.
Hertzberg?
Aye.
Hertzberg, aye. Wynn?
Aye.
Wynn, aye. Bell? Aye. Bell, aye. Hernandez? Lara? Lara, aye. Morlock? Morlock, aye. Pavley? Pavley, aye.
6-0. Hold that open for Senator Hernandez. Senator Roth, thank you very much.
Thank you, Mr. Chair, members.
Thank you. Let's quickly, before we do Senator Galgiani, let's do the consent file, which is SB 971, SB 972, and SB 973, all of which are our proposed consent matters. Moved by Senator Morlock. Secretary, call the roll.
Hertzberg?
Aye.
Hertzberg, aye. Wynn?
Aye.
Wynn, aye. Bell? Aye. Bell, aye. Hernandez? Lara? Lara, aye. Morlock? Morlock, aye. Pavley? Pavley, aye. 6-0.
6-0. Hold it open for Senator Hernandez. Next, file item number 4, SB 907, Senator Galgiani, relating to personal income tax exclusions, mortgage debt forgiveness, and urgency matter. File item number 4, members. 907.
Good morning, Mr. Chair and members. Thank you. I'm here to present SB 907. 907 would provide state income tax relief to borrowers who have had mortgage debt forgiven by their lender. This bill would apply to debt discharged in the tax years 2014, 2015, and 2016. After a loan modification, a bank can cancel or forgive thousands of dollars of an individual's mortgage debt. Federal and state income tax laws generally define this canceled debt as a form of income. Many families throughout California have experienced financial trouble over the last few years and received loan modification as a result. These same families cannot afford to pay additional taxes on money they never actually received. This legislation will help prevent excessive hardship to working families. While some areas of California have recovered, home values in many communities throughout the state are still lagging. This is a common sense measure to avoid additional fiscal burdens on those who are facing financial uncertainty as a result of the economic crisis and often unemployment. I have Hector Vasquez here with me to testify. He is a homeowner from Stockton who is directly affected by this legislation. But first, I would like to explain a little bit of firsthand knowledge to you about what is happening in some other parts of the state. I own a home in Merced County in my former assembly district. When I purchased it in 2007, I put a 20% down payment on it. This many years later, it still is not worth what I still owe on the home. As of a year ago, it was still $20,000 underwater, even though I put 20% down. I'm fortunate that I'm working and I have a long enough history ahead of me that I have the ability to pay that off. But for a working family that has had their hours cut or who has lost a job, or somebody who is in their older years, in their 60s or 70s, who has been hanging on for 9 years, like someone like myself, for them to be able to continue to hang on may not be possible. If they were to foreclose or have a short sale, the difference in what they owe, for example, with my home, the difference would be $20,000 still. They would have to pay taxes on that. Even though they're losing their life investment, they're losing everything they've been paying on for years and years, now we're going to hit them twice with making them pay tax on what they're not even getting, but it's just the difference between what they owe and what they're still underwater. I will tell you also what people like homeowners like myself are facing as well. Just this last December, 26 homes in my city on the market. Of the 26, 19 were being foreclosed. So the foreclosures are the going rate. So somebody that is not in foreclosure, their house is for sale at a much, much higher rate, and they're trying to compete with the foreclosures that are way below market. That's why the home values can't go up. So for the areas that are devastated, that have been hit hardest, that were hit first and still have not recovered, they're a long way from recovering still. That's why this bill is important, because it's unfair for families who are losing their life savings, probably in many cases, and their home right out from under them. For us to hit them a second time is just unconscionable. I respectfully ask for your aye vote.
Thank you, Senator. Sir, please proceed.
Good morning. My name is Hector Vasquez. I live in Stockton and retired 2 years ago after 28 years of service as a State of California Correctional Officer. I would like to thank Senator Galgiani for the opportunity to speak on behalf of those who short-sold their homes in 2014 and are suffering the tax burden of having to pay thousands of dollars in taxes on phantom income because Governor Brown vetoed AB 99, the Mortgage Relief Act, on October 10, 2015, a Saturday of a 3-day weekend with taxes due on Thursday, October 15th. My family and I are among thousands of Californians affected by the governor's veto. It's now the end of March 2016, and we're in collections with the Franchise Tax Board for a total of $11,034, $8,246 for taxes, and $2,798 in late fees and interest. The taxes are based on $100,000 we never received. When the bottom fell out of the market, I reached out to the mortgage companies requesting a principal reduction to no avail. I contacted the Keep Your Home program and was assigned a counselor with negative results. After researching the Mortgage Relief Act at both the federal and state level, I found it had passed both levels every year since 2007. Based on this information, my wife and I decided the best option for everyone would be to short sell our home instead of walking away and have the bank foreclose. As a result, the bank stalled the sale for 6 months, and my credit dropped from a 730 to a 520 credit rating. It should be noted that in the 12 years we lived in the home, the mortgage contract was sold to 6 different companies. My family and I could have walked away from our home. Many of my coworkers, family, friends made that decision. But like many other Californians, we were hoping to work something out with the mortgage companies. Let me share some of the comments from other Californians from the LegisScan website after Governor Brown vetoed AB 99. Tammy Smock: "It's heartbreaking. So many families now put in this horrible position. I'm shocked." Sue Beretta: "I can't believe Governor Brown would veto this bill. What can be done to correct this injustice? Please, Governor Brown, reverse your decision. Many low-to-income people are depending on you to be fair and do the right thing." Diane Pock: "How can our representatives vote yes, then one careless, uninformed person override? This is not leadership. It's stealing from the poor to give to the rich. Is there any chance of hope?" Gina Kent: "Supposedly, it's a fiscal reason he vetoed the bill. What's going to happen when we all have to file bankruptcy? How's that going to help the budget issues then? Oh, wait, we will have to pay taxes, but we'll be homeless. Guess the state would win in that situation." Valerie Urim: "Unbelievable that the governor vetoed the bill when it was passed by 100% both parties. I'm outraged and do not know how I can pay my taxes." Sylvia Alba: "This is really upsetting me. I have clients that were victims of the real estate downfall crisis. Honest, hardworking people that will never be able to pay their tax balances thanks to Governor Brown and his veto. The state needs to get it together and get these bills passed in a timely manner." Senator Galgiani has introduced SB 907 to correct this mistake. The original bill, AB 99, was supported by 100% of the Senate and Assembly, so I implore you to support this bill and urge others to do likewise. In closing, I want you to remember the thousands of your constituents who have been saddled with taxes owed on phantom income they never received because they chose to do the right thing and sell their homes instead of walking away. While it will not adversely affect the state budget, it will financially cripple families throughout the state. It is time for you to, once again, do the right thing and move this bill forward. Thank you again for this opportunity.
Thank you, sir. Thank you so very, very much. Appreciate you coming and appreciate your important testimony. Thank you. Sensla? Anybody else?
Jason Lean, California Bankers Association. We just also want to note that there's a sort of a thematic presence of affordable housing as a topic in the legislature this year, with several dozen bills introduced in the Assembly and Senate. So this is, this is a simple, non-controversial, affordable housing measure that ensures those individuals that are already in their homes can afford to keep them. So we urge an aye vote. Thank you.
Courtney Jensen with the California Credit Union League in support. We want to thank the senator for her leadership on this issue and urge an aye vote.
Thank you.
Pat Zenzela with KP Public Affairs here on behalf of the California Mortgage Bankers Association. We think this is a simple bill to help remove impediments for borrowers seeking alternatives to foreclosure, so we support the bill.
Deputy Attorney General Matt Campbell, the Attorney General's office, is in support of the bill.
Therese Tomei with the California Taxpayers Association in support of the bill. The federal government has authorized tax relief for these homeowners on the federal basis. It's continued for several years. We believe California should conform to the federal law. Thank you.
In other words, can I ask a question before you go? You mean that there is, on this phantom income, where you sell your house for less than the cost of the mortgage, at the federal level, there is relief, and this is just conformity legislation?
Yes, absolutely. That's been done since 2007. The feds have renewed it every single year. They've also renewed it for the 2015 taxable year. California is 2 years behind.
But if you're foreclosed on, you still have the phantom income problem,
Yes,
right?
yes.
But this is particularly egregious because folks that under a purchase money security interest could actually walk away, and they're not because they're trying to be responsible, then they get hit because of this policy.
Yes.
Thank you.
Christopher Carlisle, California Association of Realtors, in support of the measure. Thank you.
Thank you. Okay. Any opposition to the measure? Questions from members?
Move.
Comment.
Certainly, sir.
Supportive of the bill, and I thank the author for bringing it forward. It's really something that we need to try to fix. But also, as we talk about the folks that are now caught on this bind, I'm in the same situation with you on the home I purchased. And it's really, this is why we need to also raise the minimum wage, because a lot of the people who are not being able to make these payments are not making, they're making less than $15 an hour. So this is also something that's important that we need to do. And so I think these measures go hand in hand, and just thank you for bringing this forward.
Okay. Any further? Would you like to close?
I would like to make a comment about the HARP program, that people assume that because somebody's underwater that they can automatically just go and get help from the HARP program. It's not true. For those who had conventional loans, if they don't have a Fannie Mae or Freddie Mac loan, they are not eligible for HARP. So all of these people who put 20% down or a high amount down that were not first-time home buyers, not Freddie, not Fannie, they are not eligible for assistance. And the banks are not in a position to give them the HARP program anyway, because if they choose to do that and those loans are not Fannie or Freddie, then the banks can't get insured in case there's a loss on the loan. So some people got lucky and they were able to get the HARP program. Others just got unlucky and can't, and have hung on for years and years and years to no avail. Also complicating the problem is that to refinance, a family has to have 5% equity at a minimum in the home. So for somebody who barely breaks even and finally is no longer underwater, now they have to have 5% equity or come up with 5% cash. And again, for a family that's been struggling, or a family of seniors who are at retirement age or have retired, there's just no way to do it. And eventually people can't hang on any longer. And this is about making sure that we don't punish them a second time. I respectfully ask for your aye vote.
Senator Pavley?
And
course.
I'm certainly supporting this again. I know the governor vetoed it because his fiscal stewardship related issues, and certainly sympathize with people who tried to do the right thing and hanging on to their homes or going through a short sale instead of abandoning them. But let us not forget what caused this underlying problem. Of course, I saw The Big Short 3 times. It's the mortgage and banking interests and influence in Wall Street. We're going to go right back to this same scenario. Again, I can see the regulations weakening and the consumer oversight and the mortgage meltdown and the too easy loans, whether it's cars or whether it's homes. So I see this being an ongoing problem. I'm very sympathetic to the people caught up in the middle here and certainly supporting this bill. But I think we need to keep an eye on the bigger picture and watch politically both parties in Washington, D.C.
Right. It's a big deal. It's a really big deal. Okay, was that a motion by, I think we had a motion from Senator Lara, and this is due pass to appropriations, and then that was your close. Thank you. Secretary, call the roll, please.
Hertzberg.
Aye.
Aye. Wynn. Aye. Wynn, aye. Bell. Aye. Bell, aye. Hernandez. Hernandez, aye. Lara. Lara, aye. Morlock. Morlock, aye. Pavley. Pavley, aye. 7-0.
7-0. That measure is unanimous. Thank you very much, Senator.
Thank you.
Thank you. And sir, thank you for coming to testify. Very compelling testimony. Okay, file item next up is file item number 5, SB 927, Senator Anderson, relating to public utility district elections.